Sir, we'll start.
Yeah.
Yeah. Hi, good evening, everybody. We are here with the first lecture for the AOR examination conducted in June 2024. We have with us Mr. Basava Patil, Senior Advocate, who will be taking this lecture on the leading cases, part 1. Mr. Vipin Nair, President of SCAORA, is going to give the introductory lecture. Sir, over to you.
Good evening, good afternoon, everybody. We have taken the most toughest topic at the beginning, that is leading cases. And according to me, leading cases will be forming the structure of your other papers also, like drafting or maybe even practice and procedure and professional ethics. So this is one of the most core subjects, which is a thread between all the others. So our suggestion here is that this is the subject that requires care and some deliberation. Now, the problem here is, before I introduce my esteemed guest, a little to some advice on this is, if you approach the whole subject as 60 judgments, then you are bound to hit a wall. Instead of that, what you should do is you line up those cases according to the topics, and you'll suddenly realize that there are 15 topics covering 60 subjects, 60 judgments. So now we move on to one of our most popular and favorite seniors in Supreme Court. And as a matter of fact, Basava Patil Prabhu sir is the youngest senior advocate to be designated by the Karnataka High Court. And his jurisdictions are multiple: civil, constitutional, taxation, IT, you name it, he has done it all. And he appears all over the place. And today, as a matter of fact, he's in Gujarat High Court. And he's just come out and taken us time for us. We are grateful for him. But there is one thing apart from him. He is a famous son of a famous father. His father was a former Supreme Court Judge, Shivraj Patil, who was so loved and he was dear to all. And our Basava is a picture of humility. He will never let anybody know where he comes from. He is a man of sports. He plays badminton, he plays cricket, and he has his own cricket league in the Supreme Court League. So he's an all-rounder in all sense, and it will be a great privilege for us to hear him. Over to you, Patil, sir.
Thank you, Vipin. Good evening to all of you. A little embarrassed by the introduction which Vipin has given. I'm a sincere lawyer. I make a sincere effort on the briefs which are given to me. And my endeavor this evening will be to put across my understanding of few of the leading cases. There are 64 leading cases. It may be difficult for anyone to cover even a few cases in their limited time. But what I intend to do is just to express my thoughts on few of the cases and hope that it will be of some assistance for you all in the preparation for the examination. Leading cases, as Vipin said, it is the most important paper, not just from the AOR examination point of view, but also from the point of being a lawyer practicing in the Supreme Court. These 64 cases have been picked up so that most of the lawyers should have definite knowledge on these cases. It will help them in understanding the evolution of law, the application of law, and in drafting papers, in arguing matters. Hence, please consider this not just as a paper for your examination, but treat this as a learning curve for being a good practitioner. What should be done for these leading cases? Don't stress yourself too much from the point of view of the examinations. You can look at it as reading, understanding, and remembering. While you read these cases, as Vipin said, you can segregate them into different categories and read them under each category. When you're reading, look at what's the issue involved, what was the argument advanced by both the sides, considered or dealt, reasoning, and the rationale for conclusion. If you do this, then it helps in your understanding as to why this is a leading case or what's the principle of law that has been enunciated. You should also look at evolution, that is, where did it start? Just don't look at this case, which is given to you in the list of 64 cases. It has its origin somewhere. Where did this issue arise first? So you'll read about the evolution. Then, after the judgment which is prescribed, look at the subsequent developments on the said point. That will complete the reading and which will also help you in understanding and having conceptual clarity. So it's important to read first from this point of view, understand it, and have conceptual clarity. Once you have done this, by repeated reading and application, you'll easily remember it. If your understanding is clear, remembering it becomes easier. So please understand the concept so that you remember it easily, whether it's exam or it's practice. With this, I have made a few cases for presentation. One I want to start is with the famous judgment in Kailash Nath Associates versus Delhi Development Authority, 2015 4 SCC 136. This case dealt with the issue or the interpretation of Section 74 of the Contract Act. This judgment is very important because it comes for application in many cases wherever contracts are involved and breach of contract takes place. Section 74 of the Contract Act says what? When a contract, compensation for breach of contract where penalties stipulated for. It reads, when a contract has been broken, if a sum is named in the contract as the amount to be paid in case of such breach, or if the contract contemplates any other stipulation by way of penalty, the party complaining of the breach is entitled, whether or not actual damage or loss is proved to have been caused, thereby to receive from the party who has broken the contract reasonable compensation, not exceeding the amount so named, or as the case may be, penalties stipulated there. Most of us, when we read this section in the Contract Act, we think that if there is a sum named as liquidated damages, then if there's a breach of contract, I'm straight away entitled for that amount. I need not prove the loss that has been caused. This impression is there with most till we read Section 73, 74, and 75 together, and the arguments that have been advanced as regards the interpretation of Section 74 in particular. The most important or the constitutional bench judgment in regard to the interpretation was in Fateh Chand versus Balakrishna Das, wherein Supreme Court said this section is clearly an attempt to eliminate somewhat elaborate refinements made under the English common law in distinguishing between stipulations providing for payment of liquidated damages and stipulation in the nature of penalty. Under the common law, a genuine pre-estimate of damages by mutual agreement is regarded as a stipulation naming liquidated damages binding between the parties. A stipulation in a contract in terrorem is a penalty, and court refuses to enforce it, awarding to the agreed party only reasonable compensation. Indian legislature has sought to cut across the web of rules and presumptions under the English common law by enacting a uniform principle applicable to all stipulations, naming amount to be paid in case of breach and stipulation by way of penalty. Then we have an interpretation that if there is a liquidated damages an amount has been quantified, how does it pan out? This is applicable when court is unable to assess compensation and the sum named by the parties is to be regarded as genuine pre-estimate in consideration as a measure of reasonable compensation. So whenever there's a breach, a party is entitled for reasonable compensation. This pre-estimate by the parties, if it is a genuine pre-estimate, that requires to be awarded as reasonable compensation. Is it sufficient if it is mentioned in your contract that this is a reasonable compensation and this is a genuine pre-estimate and therefore it has to be paid? The court considered this and held that first, it should be a reasonable pre-estimate agreed by both the parties. Secondly, it should be accepted by the court. Just because parties put it in the contract does not make it a genuine pre-estimate. It has to be accepted by the court. So the court in Kailash Nath noted a few judgments, and while noting the judgments, after discussion, it has held that the terms of the contract are required to be taken into consideration before arriving at the conclusion whether the party claiming damages is entitled for the same. If the terms are clear and unambiguous, stipulating liquidated damages in case of breach of the contract, unless it's held that such estimate of damages and compensation is unreasonable or is by way of penalty, party who has committed the breach is required to pay the compensation, and that is what is provided in Section 73. Section 74 is to be read along with Section 73, and therefore, in every case of breach of contract, the person aggrieved by the breach is not required to prove actual loss or damage suffered by him before he can claim a decree. The court is competent to award reasonable compensation in case of breach, even if no actual damage is proved to have been suffered in consequence of breach of a contract. In some contracts, it would be impossible for the courts to assess the compensation arising from breach, and if compensation is not by way of penalty or unreasonable, the court can award the same if it is a genuine pre-estimate by the parties as the measure of reasonable compensation. The court has indicated what? If it is impossible for the court to assess the compensation arising from the breach, and if it feels it is not in the nature of a penalty, it is not unreasonable, as also it was a genuine pre-estimate, then only the amount indicated can be awarded. After considering Fateh Chand and Maula Baksh, Justice Rohington in Kailash Nath at para 43 has concluded, on a conspectus of the above authorities, the law on compensation for breach of contract under Section 44 can be stated as follows. Where a sum is named in a contract as liquidated amount payable by way of damages, the party complaining of breach can receive as reasonable compensation such liquidated amount only if it's a genuine pre-estimate and found to be such by the court. In other cases, where a sum is named in a contract as liquidated amount payable by way of damages, only reasonable compensation can be awarded, not exceeding the amount so stated. Similarly, in cases where the amount is fixed, is in the nature of penalty, only reasonable compensation can be awarded, not exceeding penalty so stated. In both the cases, liquidated amount or penalty is the upper limit beyond which the court cannot grant reasonable compensation. Normally, we are under the impression that whenever an amount is put in the contract as liquidated damages, that amount requires to be paid. There is no need to prove the loss, is perhaps not accurate understanding of Section 74. It's important to demonstrate that there is a breach, there is a legal injury, and then it is not possible to assess the damage. Therefore, there has been a genuine pre-estimate which requires to be accepted and awarded as reasonable compensation. Only then you get this compensation in terms of what has been contracted. The next point where the court holds is reasonable compensation, how it has to be fixed, will be fixed on the well-known principles that are applicable to the law of contracts, which are to be found inter alia in Section 73 of the Contract Act. Section 74 awards reasonable compensation for damages or loss caused by breach of contract. Damage or loss caused is a sine qua non for applicability of the section. The section applies whether a person is a plaintiff or a defendant in suit. The sums spoken of may already be paid or payable in future. The expression whether or not actual damage or loss is proved to have been caused thereby means where it is possible to prove actual damage or loss, such proof is not dispensed with. Please note that where it's possible to prove actual loss, such proof is not dispensed with merely because the words used in Section 74 contemplate that whether or not actual damage or loss is proved. It does not mean where it's possible to prove it is dispensed with. It's only in cases where damage or loss is difficult or impossible to prove that the liquidated amount named in the contract, if a genuine pre-estimate or damage or loss can be awarded. So if you look at the evolution of law, the court has considered right from what original Section 74 read, what was the amendment brought about, what was the decision of the Constitution Bench in Fatehchand, followed by Maula Baksh, then Kailash Nath. So this has become a leading case because it lays down the fundamental principles as to how Section 74 has to be interpreted for enforcements in relation to breach of contracts. As the persons who are going to write the AOR examination, my suggestion to you is please don't stop at 2015 4 SCC 136. It is necessary for you all to look further and see how this has been followed, if it has been followed, if there has been any distinction that has been brought about from what has been held here. There is actually a decision right up to 2024 on this point. I think 2023 in Deshraj and others versus Rohitesh Singh. So please look up the judgment. It will be useful in understanding as to how, if you are the counsel for the petitioner, respondent, plaintiff, defendant, when you draft, when you plead, how you have to do so. That will help you fetch good marks besides good understanding, and it will be useful to each one of you for all the times to come. My suggestion is please look at leading cases as an ongoing reading of them as an ongoing debate. The best way of learning these leading cases and the rationale is to debate amongst yourself and continue to debate with all concerned at all points of time, so that your clarity of thought will come in, as also you will remember concepts very clearly. With this, I will go to the next case, which I thought has a significant bearing, and that's why it has been marked as a leading case. The second one would be 2005 8 SCC, page 618. This is SPB and Company versus Patel Engineering. This is a leading case under the Arbitration and Conciliation Act 1996. You're all aware, or you should be aware by now, that the decision in Konkan Railway Corporation versus Mehul Construction or Konkan Railway Corporation versus Rani Construction treated the power of the Chief Justice, his designate, to appoint arbitrator to be administrative in nature, on the ground that while appointing an arbitrator, the Chief Justice, his designate, did not act as judicial authority. Resultantly, the order of the Chief Justice could be challenged before the High Court under Article 226, then before the division bench in a letter patent appeal or a writ appeal, and then before the Supreme Court under Article 136, which would further delay arbitration proceedings. So the law, as declared by the Supreme Court, was that the exercise of this power is administrative in nature, and the course to follow after an administrative decision is taken to appoint or not to appoint is to challenge it by way of a writ appeal, and a special petition before the Supreme Court. This fell for consideration as to whether it's an administrative function or the function discharged by the judge, the designate, is judicial function, quasi-judicial function, or merely an administrative function in SBP and Company versus Patel Engineering. The 7-judge bench brings out why it is not an administrative function, but a judicial function. And being a judicial function, it has to be discharged by the Chief Justice or a judge designated by him. It cannot be delegated to an administrative body. And what will be the consequence of such a discharge as a judicial, quasi-judicial function being discharged? Para 11 of this judgment is important. It reads that the appointment of an arbitrator against the opposition of one of the parties on the ground that the Chief Justice has no jurisdiction, or on the ground that there was no arbitration agreement, or on the ground that there was no dispute subsisting which was capable of being arbitrated upon, or that the conditions for exercise of the power under Section 11(6) do not exist, or that the qualification contemplated by the arbitrator by the parties cannot be ignored and has to be borne in mind, are all adjudications which affect the rights of the parties. It cannot be said that the Chief Justice decides that he has jurisdiction to proceed with the matter, and there's an arbitration agreement, and that one of the parties to it has failed to act according to the procedure agreed upon. He is not adjudicating on the rights of the parties, which is raising these objections. What the court says is, if I make an application for appointment of an arbitrator, the other side disputes as to the fact that there exists a dispute, there exists an arbitration agreement, or that the person making the application is a party to the agreement, or the person whom they want to appoint is qualified as an arbitrator or not. If they are to be adjudicated upon because the other side is disputing, it will definitely affect the right of the parties if any decision is taken on that. That being so, when it involves adjudication of a dispute, it becomes a quasi-judicial function. Being so, it has to be discharged by whom? And if that is so, it certainly can't be, when it affects the rights of the persons, it cannot be held to be a administrative function. This is what the court notes in para 11. The next important paragraph in that judgment, which will throw light, is para 36. Going by the above test, it is seen that at least in the matter of deciding his own jurisdiction, in the matter of deciding on the existence of an arbitration agreement, the Chief Justice, when confronted with 2 points of view presented by rival parties, is called upon to decide between them, and the decision vitally affects the right of the parties in that either claim of appointing an arbitral tribunal leading to an award is denied to a party, or the claim to have an arbitration proceeding set in motion for entertaining a claim is facilitated by the Chief Justice. In this context, it is not possible to say that Chief Justice is merely exercising administrative function. When called upon to appoint an arbitrator, and he need not even issue notice to the opposite side before appointing an arbitrator. In para 37, the court noted it's fundamental to our procedural jurisprudence that the right of no person shall be affected without being heard. This necessarily imposes an obligation on the Chief Justice to issue notice to the opposite party when he is moved under Section 11 of the Act. The notice to the opposite party cannot be considered to be merely an intimation to that party of filing the arbitration application and passing an arbitration order, appointing an arbitrator. It is really giving an opportunity of being heard. There have been cases where claim of appointment of an arbitrator based on an arbitration agreement, which are made after 10 or 20 years, after the period of contract has come to an end. There have been cases where the appointment of an arbitrator have been sought after the parties have settled their accounts and the parties concerned had certified that he has no further claim against the other contracting party. In other words, they have occasions when dead claims are sought to be resurrected. There have been cases where assertions are made of the existence of an arbitration agreement when in fact such existence is strongly disputed by the other side who appears on issuance of notice. Controversies are also raised as to whether the claim that is sought to be put forward comes within the purview of arbitration clause. The Chief Justice has necessarily to apply his mind to these aspects before coming to a conclusion one way or the other, and before proceeding to appoint an arbitrator or declining to appoint an arbitrator. Obviously, this is an adjudicatory process. An opportunity of hearing of both the parties is a must, even in administrative function if rights are affected. Rules of natural justice will step in. Therefore, the court notes that when there is a contest, there has to be notice, there has to be an opportunity, and there has to be a decision. Consequently, it is a quasi-judicial exercise of power and not an administrative exercise of power. And then in para 39, the court says what should be decided at the stage of appointment of an arbitrator. It is necessary to define what exactly the Chief Justice approach with an application under Section 11 is to decide at this stage. Obviously, he has to decide his own jurisdiction in the sense whether party making the motion has approached the right High Court. He has to decide whether there's an arbitration agreement as defined in the Act, whether the person who has made the request before him is a party to such an agreement. It is necessary to indicate that he can also decide the question whether the claim was dead one or a long barred claim that was sought to be resurrected, and whether the parties have concluded the transaction by recording satisfaction of their mutual rights, obligations, or by receiving final payment without objections. It may not be possible at that stage to decide whether a live claim made is one which comes within the purview of arbitration clause. It will be appropriate to leave that question to be decided by the arbitral tribunal on taking evidence along with the merits of the claims involved in the arbitration. The Chief Justice has to decide whether the applicant has satisfied the conditions for appointing arbitrators under 11(6) of the Act. For the purpose of taking a decision on these aspects, Chief Justice can either proceed on the basis of the affidavits and documents produced, or take such evidence or get such evidence recorded as may be necessary. We think that adoption of this procedure in the context of the Act would best subserve the purpose sought to be achieved by the Act, expediting the process of arbitration without too many approaches to the court at various stages of the proceeding before the tribunal. The court here is indicating that when a Section 11 application is filed, it's not just an administrative discharge of function and you appoint an arbitrator. You look at the jurisdictional issues in the first instance as to whether there's an arbitration clause, whether the right person has made the application, whether this High Court is competent to decide whether there's a time-barred claim. But if it's on the merit of the matter, then it's important that that issue is left to the arbitrator appointed to decide it. So the court appointing an arbitrator will necessarily take a call on the disputed issues as to the jurisdiction to go ahead, appoint, and have it adjudicated by the arbitrator. Then The very scheme, if it involves an adjudicatory process, restricts the power of the Chief Justice to designate by excluding the designation of non-judicial institutions or a non-judicial authority to perform the function. For under our dispensation, no judicial or quasi-judicial decision can be rendered by an institution if it is not a judicial court or a quasi-judicial tribunal. This is very important. You should note that can the Chief Justice delegate this function to a non-judicial institution, especially because it is going to be discharging or adjudicating as a quasi-judicial authority. In our system, a non-judicial authority is not empowered to decide or to act as a quasi-judicial authority. In para 17 further, the decision contemplated is not for the purpose of deciding the preliminary facts justifying the exercise of power to appoint an arbitrator, but only for the purpose of nominating to the Chief Justice a suitable persons to be appointed as arbitrator, especially in the context of section 11.8. One of the objects conferring power on the highest judicial authority in the state or in the country for constituting arbitral tribunal is to ensure credibility in the entire arbitral process. And looked at that from the point of from that point of view, it is difficult to accept the contention that Chief Justice could designate a non-judicial body like Chamber of Commerce to decide on the existence of arbitration agreement, so on, which decisions normally judicial or quasi-judicial in nature. Where a Chief Justice designates not a judge, but another person of an institution to nominate an arbitral tribunal, they can be done only after the question of jurisdiction, existence of the agreement, and the like are decided by him or his nominee judge. What is left to be done is only to nominate the member constituting the tribunal. So this gives a clear picture that the designation has to be to a competent person, and under the Act, the highest authorities have been empowered to do so, and only if it's question of naming that can be left to a non-judicial body. Then the question is whether Chief Justice can designate a district judge was also considered in this case, and the court holds to perform the functions under 11.6. We have seen that the definition of the court in the Act, we have reasoned that the intention of the legislature was not to entrust the duty of appointing an arbitrator to district judge. Since the intention of the statute was to entrust the power to the highest judicial authorities in the state and in the country, we have no hesitation in holding that the Chief Justice cannot designate a district judge to perform functions under 11.6 of the Act. This restriction on power of the Chief Justice on designating a district judge or a non-judicial authority flows from the scheme of the Act. So they have eliminated delegation to a district judge or to a non-judicial authority. Further, in para 43, they note that there is an ocean of difference between an institution which has no judicial function and an authority or a person who is already exercising judicial power in his capacity as judicial authority. Therefore, only a judge of Supreme Court or a judge of the High Court could respectively be equated with the Chief Justice or the Chief Justice of the High Court while exercising the power under 11.6 as designated by the Chief Justice. A non-judicial body or institution cannot be equated with a designation contemplated by 11.6 of the Act and is not designation to an institution that is incompetent to perform judicial function. Our dispensation, a non-judicial authority cannot exercise judicial powers. Majority in this Patel Engineering summed up the conclusion in the following terms. The power exercised by the Chief Justice is not an administrative power, it's a judicial power, first. Second, Section 11.6 in its entirety could be delegated by the Chief Justice only to another judge of that court, by Chief Justice of India to the judge of the Supreme Court. This is the second one. Third, in case of a designation of a judge of the High Court or Supreme Court, the power that is exercised by the designate would be that of the Chief Justice conferred by the statute. Fourthly, the Chief Justice or a designated judge will have a right to decide the preliminary issues, aspects as indicated in the earlier part of the judgment. These will be his own jurisdiction to entertain the request, the existence of valid arbitration agreement, the existence or otherwise of a live claim, the existence of conditions for exercise of his power, the qualification of the arbitrator or arbitrators. The Chief Justice or the designated judge would be entitled to seek opinion of the institutions in the matter of nominating arbitrators qualified in terms of 11.8. So they say that you can take opinion if need arises, but the order appointing arbitrator could only be that of the Chief Justice or a designated judge. Fifthly, designation of a district judge as an authority under 11.6 is not warranted on the scheme of the Act. Sixth, once the matter reaches the arbitral tribunal, the sole arbitrator, the High Court, would not interfere with the orders passed by the arbitrator or arbitral tribunal during the course of arbitration proceedings, and the parties could approach the court only in terms of Section 37 of the Act or in terms of Section 34 of the Act. Seventh, since an order passed by the Chief Justice of the High Court or designated judge of the court is a judicial order, an appeal will lie against that order only under 136 of the Constitution to the Supreme Court. There can be no appeal against an order of the Chief Justice of India or judge of the Supreme Court designated by him while entertaining an application under Section 11.6. In case an arbitral tribunal has been constituted by the parties without having recourse to Section 11.6 of the Act, the arbitral tribunal will have jurisdiction to decide all matters contemplated under Section 16. So there has been a major shift from holding that it's an exercise of the power is administrative in nature to holding it's a judicial order and appeal will lie only to the Supreme Court. This was laid down by majority in SBP and Company versus Patel Engineering. Now, as a consequence of this decision, the scope of inquiry appointing arbitrator was enlarged. The Chief Justice had to decide existence of arbitration agreement. It also had to decide party applying for appointment was a party to the agreement, whether the claim was dead or alive, and conclude and record satisfaction of the mutual rights and obligations. To determine the existence of the arbitration agreement, it had to satisfy by documents containing arbitration agreement, whether it's sufficiently stamped in all of them. The expanse of this jurisdiction led to delay in appointments. Therefore, it is sought to be now limited by bringing in some amendments in 2015 as also in 2019. So my suggestion is, this is a leading case. It is indicating a major shift, but you have to look up for the developments which have taken place subsequent to the judgment in SBP and Company for updating your knowledge and answering the questions. But this fundamental and conceptual fact that it is exercising judicial function is to be borne in mind, as it's an important principle which has been brought out by this judgment. Now, I will move on to a third case, which is Shanti Conductors Private Limited, 2022 SCC, page 677. In this case, interpretation of Section 19 of the Limitation Act, Order 7, Rule 6, came up for consideration, and the Supreme Court has interpreted this and applied. And this is also a leading case on the principle of application of Section 19 and Section Order 7, Rule 9. This was a case where there was an order for supply. The supply was completed on 4/10/1993. But the last payment was made on 5/3/94. The issue was whether the limitation begins from 4/10/93 or it is from the date of payment, that is 5/3/94. Reliance was sought to be placed on Section 19 of the Limitation Act to claim that it is from the date of payment. In para 12, they extract this section 19 of the Limitation Act. It reads, effect of payment on account of debt or interest on legacy. Where payment on account of a debt or interest on legacy is made before the expiration of the prescribed period by the person liable to pay the debt or legacy or by his agent duly authorized in this behalf, a fresh period shall be computed from the time when the payment was made, provided that, save in the case of payment of interest made before the 1st day of January 1928, an acknowledgement of payment appears in handwriting or writing signed by the person making the payment. The court also considered Order 7, Rule 6, which is extracted at para 14, which reads, grounds for exemption from limitation law. Where a suit is instituted after the expiration of the period prescribed by law of limitation, the plaintiff shall show the ground upon which exemption from such a law is claimed, provided the court may permit the plaintiff to claim exemption from the law of limitation on any ground and not set out in the plain if such ground is not inconsistent with the plain. The court considered all of this and said that unless it is in writing and you have pleaded based on this, you are seeking exemption in terms of Order 7, Rule 6, you will not be entitled for the relief. While discussing this, they noted in the facts of this case that you have not pleaded, and now what you are contending, even if it's not pleaded, it should not be opposed to what is contained in the plaint, whereas it is contrary to the plaint. Hence, it would not be permissible to accept Order 7, Rule 6 coming to the rescue of the petitioner in this SLP. The court has dealt with these aspects elaborately because though it was considering a review, it noted what the law on the point is in a few of the paragraphs. Because of paucity of time, I will not dwell deep into this. It also notes that Order 47, Rule 1, what is the scope of it, and has concluded that in the facts of this case, the petitioners were not entitled for the relief because there was no acknowledgement of the debt in writing and there was no pleading while claiming for exemption from the law of limitation. So this can be an important case law for considering the true scope and purport of Section 19 and Order 7, Rule 6. There are a bunch of cases, that is L. Chandar Kumar, 1995, 1 SCC, page 400 of 3 judges. Roger Matthew versus South India Bank, 2026 SCC, page 1. Madras Bar Association versus Union of India, 2021, 7 SCC, page 369. These three cases deal with power of judicial review and independence of tribunals. As in the beginning, the SCAORA president mentioned that you can club these cases for the purpose of study and the understanding becomes complete. In these cases, what was brought out was the 42nd Amendment to the Constitution, inserted in Part 14A of the Constitution, comprising of Article 323A and 323B, with effect from 1377. Article 323A provided the Parliament to provide adjudication of service matters under the Union by administrative tribunals. 323B enabled appropriate legislature to provide by law for adjudication of any disputes with respect to levy, assessment, collection, enforcement of any tax, foreign exchange, industrial and labor disputes, land reforms, sealing of urban property, elections, etc. Laws thus made could provide for establishment of administrative tribunals, specifying jurisdiction, power, authority to be exercised by such tribunals, the procedure to be followed by such tribunals. 323A and B provided that they have effect notwithstanding anything in any other provision of the Constitution or any other law for the time being in force. In exercise of power under 323A, Parliament brought about Administrative Tribunals Act with an objective that the Administrative Tribunal will deal with service matters exclusively for speedy relief to the aggrieved person and reduce the burden on various courts. There was a provision made for exclusion of jurisdiction of the High Court under Article 226 and 227 of the Constitution in service matters covered by the said enactment and vesting exclusive jurisdiction in such service matters to administrative tribunals, though the jurisdiction under Article 32 and 136 was not excluded. The vires of this came up for consideration in Sampath Kumar's case, and it was challenged on the ground that judicial review is a basic structure of the Constitution. Exclusion of jurisdiction of the High Court under Article 226 and 227 as regards service matters could not be sustained. The challenge was considered. The bench held that exclusion of jurisdiction of the High Court in service matters, particularly when the jurisdiction of the Supreme Court under 32 and 136 was not affected, did not totally bar judicial review, and that it was possible to set up alternative institutions in place of the High Court for providing judicial review. That, however, the tribunal should be a real substitute for High Court, not only in form, but in content. Regarding qualification of the members of the tribunal, bench held judicial discipline generated by exercise, experience and training in an adequate dose being necessary qualification for the post of chairman. Ordinarily, a retiring or a retired Chief Justice of the High Court, or when such a person is not available, a senior judge of proved ability either in office or retired should be appointed as chairman. That the office should, for all practical purposes, be equated with the office of the Chief Justice of the High Court. Selection of the vice chairman and member, when it is not a sitting judge or retired judge of the High Court, should be done by a high-powered committee with a sitting judge of Supreme Court to be nominated by the Chief Justice of India as its chairman. This will ensure proper selection of competent persons to man these high offices of trust, help to build the reputation and acceptability. So this is what Sampath Kumar says, that even though jurisdiction under 226 is taken away, it is not invalid because there is a remedy available before the Supreme Court. However, they said the appointment should be of the highly qualified people, preferably a retired or retiring judge, if not by a committee constituted of the judges. Post Sampath Kumar, there have been several decisions rendered by different benches of Supreme Court. A division bench of Supreme Court, a division bench in JB Chopra versus Union of India, 87-1, SCC 422 held that tribunals have jurisdiction, power and authority to even adjudicate upon the questions relating to constitutional validity of rules framed by President of India under proviso to Article 309 of the Constitution. And the tribunal could even adjudicate the vires of the Act of Parliament and state legislature. So they virtually held that the administrative tribunal is on par with the High Court, and they can go into the validity of the rules framed by the President under Article 309, as also the vires of the Acts of Parliament and state legislature. In another decision, Amulya Chandra, it was held that the administrative tribunal member of the tribunal alone could not hear and decide a matter. This decision was rendered without noticing the provisions of the Administrative Tribunals Act, which permitted the chairman of any member or any member authorized by the chairman to function as a bench consisting of a single member. So, though there was a provision for the chairman to delegate it to a single member, and that could be an administrative member, he could decide. This was not noticed, but they said it can't be done by an administrative member. The point was again examined in 3 judges bench in Mahabalram and others in 1994 to SCC, which held that while allocating the work to a single member, whether judicial or administrative, the chairman should keep in view the nature of litigation and whether question of law and interpretation of constitutional provisions are involved. Such matters should not be assigned to single members. I am bringing out these to understand the evolution of law in relation to tribunalization, their jurisdiction, and exercise of power. A 3-judge bench in state of Orissa versus Bhagban Sarangi, without reference to an earlier precedent including Sampath Kumar, held that the tribunal is bound by the decision of the High Court of the state and cannot sidetrack or bypass the decision of the High Court. Then, in another decision, MB Majmudar versus Union of India did not accept equality claimed by member of administrative tribunal with the judges of the High Court in the matter of pay and age of superannuation on the ground that the pattern and scheme of statute establishing the tribunal was different. Another bench of 3 judges in RK Jain emphasized the need for members of the tribunal having adequate legal expertise, judicial experience, and legal training to enable tribunal to become effective alternate institutional mechanism to dispense with High Court's power of judicial review. 3-judge bench in L. Chandar Kumar, 1995, 1 SCC 400, held that Administrative Tribunal Act permitted assignment of matters to single member. The validity of such provision was assailed before 3-judge bench in Chandar Kumar. Before the bench, it was argued that in view of Sampath Kumar, judicial power need not always be exercised by regular courts, was contrary to the dicta in Keshwananda Bharati. Therefore, taking note of the decisions post Sampath Kumar, the bench held the aforesaid post Sampath Kumar cases do require, in our considered view, a fresh look by a larger bench over all the issues adjudicated by this court in Sampath Kumar's case, including the question whether the tribunal can at all have an administrative member on the bench. If it were to have power to even decide constitutional validity of statute or 309 rule, as conceded in Chopra's case, examination of this aspect would be necessary to instill confidence in the minds of the people, which is of greater importance in judiciary. The significance of the decision in Chandar Kumar is that bench of 3 judges required a decision rendered by a larger bench of 5 judges in Sampath Kumar reconsidered by a larger bench. I'm just giving a note as to the fact that whether a 2-judge bench can say 5-judge bench requires consideration, or 3-judge bench can say that 5-judge bench decision requires reconsideration, that have all been considered. I think then there has been there have been several decisions in line with this to protect the independence of judiciary, even in tribunals, because tribunals are functioning to supplement or do what the High Court was required to do. The appointment procedure requires that majority in the appointing committee are judicial members. There are decisions in that regard. I don't think we have time beyond this to go into it. I have prepared some note as regards these three cases on Chandar Kumar, Roger Matthew, and Madras Bar Association, because they're all very lengthy judgments involving evolution of law and the progress in regard to power of judicial review and independence of tribunals. If it is of any help, I will pass it on to this SCAORA, and if anyone is interested in going through it, are welcome to do so. Thank you all for having me and listening to me of 2 bits of what I thought is relevant.
Thank you so much, sir. I believe not only just the aspirants, but even AORs like me would have benefited from this, sir. It was a refresher course for all of us, I must say. Sir, I'll now ask Mr. Nikhil Jain, the Secretary of SCAORA, to give you a vote of thanks, sir, before we part ways.
Thank you so much, sir. On behalf of SCAORA, I would like to thank you for accepting our invitation and sharing your views on the leading cases. It was indeed such an inspirational talk by your lordship, sir. And I would also thank our President, Mr. Vipin Nair, Asthaji, who was the moderator, and other EC members for this lecture. Thank you, sir.
Thank you. Thank you all.
Thank you, sir.